That case. That was a landmark case that redefined self-defense in the state. It was a guy, Kenneth Wood, was charged with assaulting a police officer and resisting arrest. But he reasonably believed that the police officers were using unlawful force against him because it was beyond the minimal force necessary to bring him into custody. The state Supreme Court eventually ruled with Kenneth Wood, saying that, yeah, he did have reason to believe that the officers were using unlawful force against him. He acted in self-defense against the officers. And it's not what the officers intended to do to him, it's what he perceived what the officers were doing to him. Just like me. It doesn't matter what Carenza's intents were. It doesn't matter. I'll take questions at the end, thank you. It doesn't matter what the other people involved, it doesn't matter what their intent was or what they're saying their intent was. It's what I believe their intent to be. So if I haven't made it clear, my actions were solely in self-defense throughout this whole thing. So of course, when it comes time for the jury to come in, the whole jury's tainted. Everybody's heard about the story. Everybody's heard the things Kate Molina said in the news. Everybody's heard all this untrue stuff that everybody said about me. Some of the people in the jury were at the protest. Some of the people... Yeah. Really? Some of the people have been to other protests I've filmed. Now, one of the things... Well, I'll get to that. So one of the things that I focused a lot of my journalism on was Second Amendment related stuff. I like to film what the anti-gun people were saying and doing. One of those organizations was called Ceasefire Oregon. I had filmed several of their events. I had actually found other videos of their director, Penny Okamoto, saying all sorts of crazy things. Longtime fans of my channel know who Penny Okamoto is. She's the babbling blonde idiot. So that was one of the groups that I focused a lot on. One of the people on the jury is a volunteer for Ceasefire Oregon and has known about me for years. So all of our fears about a tainted jury came to fruition. So John Slaughter is one of the witnesses to this. He was on the steps here. So he gets on the witness stand. At first he's saying that I was open carrying. He was telling the detectives that I was click-clacking my gun throughout the protest, pulling it out, unloading it, reloading it during the march. What? No, I loaded my gun at home. And then he's saying, well, I didn't know. I didn't see him. He was concealed carrying. First you're saying I'm open carrying, then you're saying I'm concealed carrying, then he admits that he didn't actually see any of this. He's just going off of third-hand knowledge from what he heard other people saying. He said this both to the detectives and on the witness stand. Previously, right along the time that Jelani Sharif was calling for shooting police officers, John Slaughter, at that same thing, right at the same thing, was calling for people to carry guns at work. I have that as a video on my channel. He's saying, if you work a job where you're not allowed to have a gun, you're not allowed to carry it at your work, you need to quit your job. Thank you. You're supporting my work. Thank you. You're justifying my actions. John Slaughter admits to taking part in the plan to confront me. Forcibly remove me was the language that he used in the interview with the detective. He said that there was a text message conversation going on between him and a whole bunch of other people about how they were going to come and confront me and forcibly remove me from the area. He's on the witness stand saying that some of the people who were involved in this attack on me were armed with guns themselves. They're ex-military, they're martial arts people. Carenza's on the witness stand, the big dude. He's admitting to conspire against me. He's saying, oh yeah, several individuals approached me, they informed me Stricklin was in the crowd, and so we went in to get him. You have these people admitting on the witness stand that they planned all of this out to come and physically confront me.
Physically remove you, wasn't it?
Physically remove me, physically confront me. Now, I consider Benjamin Carenza's actions against me to meet the statutory definition of coercion, which is using force or intimidation to prevent someone from engaging in an activity that they have a lawful right to engage in. I'm exercising my First Amendment rights. He's using force and threats to prevent me from doing such. Because he's doing this with 5 or more people, I believe this meets the statutory definition of riot, which is when you're engaging with 5 or more people in a deliberate act to cause panic and alarm to the public. Along with harassment, assault, disorderly conduct, menacing. If that were a police officer there and Carenza did that, would that be considered assaulting an officer?
Yeah.
The standard is the same, it's just the level of crime changes. So Todd Jackson, the other district attorney who's working on the case, he's defending the notion of protesters wearing masks while they're engaging in physical assaults on people. He's saying, no, it's not to appear threatening, it's not to appear menacing, it's not to conceal your identity so you don't get caught. It's for personal protection. To prevent against stalking and harassment should members of the public or certain journalists learn of your identity. So if someone's out there if they're holding up the liquor store and they got a mask over their face, do they get to go into court and say, oh, it wasn't because I wanted to hide my identity or to scare the guy behind the counter. It was because I didn't want anybody to harass me afterwards. That's what the prosecutors are arguing about.
Quick note, we have a half an hour extension.
Half an hour, thank you very much. And it looks like Randy's leaving. Okay, thank you. You've kept up with a lot of, you know everything I'm saying anyways.
I do.
So we thought we were winning this case because we have these guys on the stand admitting that they planned this coordinated attack on me. We have all the video evidence of them doing it. We have the video evidence of me exercising my diligence to get away from the scene. We thought we were winning the case. So we bring up, so the way the trial works is they give your opening arguments, the prosecution brings up all their witnesses, makes their case, the case in chief as it is called, and then they rest, and then we present our case. We only brought up a couple witnesses, a couple of which are in this room. I will leave out names for right now. One of the witnesses we brought up that they knew we were going to bring up is a use of force expert. He's the former firearms trainer for the Gresham Police Department. He also trains civilians. Of course, he concludes that everything I did was correct, in line with self-defense, in line with CHL holders are trained to do, that I acted appropriately and reasonable under those circumstances. So then we rest our case. And then the prosecutors say, oh, wait, we want to bring up one more guy. Wait a minute here. You already made your case. You already brought up all your witnesses. You already rested. They want to bring up their own use of force expert now. They had plenty of opportunities to do this. Of course, we argued against this because they had plenty of opportunities. They knew at least a month in advance that we were going to be bringing in an expert use of force witness. So they bring in this guy, Officer Ryan Rasmussen of the Gresham Police Department. He's now the current use of force and firearms trainer. And he's basically saying that everything I did was wrong, no one's trained to do this, blah, blah, blah. There's one problem with his testimony, though. His only experience with firearms is in military and law enforcement. He went into the Marines, he got out of the Marines, he did some armed security, and then he joined the police force. He has no experience as a civilian, he's not qualified to train civilians, he's never been through civilian-based courses. His testimony could only relate to what police would be able to do in a similar circumstance. One interesting thing is he said police are not trained to pull a gun, point it at someone, and not shoot, and then reholster. So they're kind of vaguely stating that if you're going to pull your gun, you have to shoot. And as I explained, the threat was neutralized just by the act of drawing. And so his statements there I find interesting, because I personally have seen police officers draw their firearms on people, issue verbal commands, the person complies with the commands. For example, a guy has a knife out, police draw their guns, drop the knife, guy drops the knife, threat's alleviated, gets his hands up, police reholster their gun. I personally have seen things like that. I know you guys have all probably seen things like that. The cop watcher contingent here. So he's saying that police officers are not trained to do that. So if you see anybody out there, if you see an officer pulling a gun on someone, not shooting and reholstering, get in contact with the person they drew the firearm on, get them in touch with attorney Sean Riddell, because I think that's a lawsuit right there. Because you have this guy on the witness stand saying police aren't trained to do that. That's a crime if it's me doing it. Shouldn't it be the same thing with police? Another interesting thing about Ryan Rasmussen is he's saying his police department does not use use of force continuum charts and wheels and things like that. There's numerous ones that are in firearms training, use of force training. He's saying that they don't use those. But what's interesting is that we obtained testimony that he had previously given just a year prior, stating that his department does in fact use such wheels and charts. So now we have him lying to the judge on the witness stand, just as Kate Molina and Todd Jackson have lied to people, just like Benjamin Carenza's on the stand lying, just like John Slaughter's on the stand lying. We've now caught a police officer lying to Judge Thomas Ryan on the stand. So Rasmussen himself, I think, has bad judgment because he allowed a mob of people to attack him on a Max platform one time. So it came time for the verdict. And throughout the verdict and the sentencing, the judge said some interesting things. He said, this is not about what he said something to the effect of, this is not about what other people were doing, this is what Stricklin did. To me, that indicates that the judge refused to take into consideration self-defense. Because self-defense is entirely predicated on the actions of what somebody else is doing. By him saying it's not about those actions, he's saying that he refused to consider self-defense. He said things to the effect of, you had other options. I've exercised a lot of those options. No one's explained to me what I should have done. People who disagree with me, no one's explained what someone should do in that particular situation. I'll welcome that under the question and A period. Not right now, during the Q&A. Thank you.
I was just wondering, what do you think the police agenda is?
I don't know. I can't speculate to that. Maybe I'll get into that a little later on.
Do you feel like they failed that?
I don't know. It's a complicated situation. I'll put it that way. But so no one's explained what someone should do in that situation. The only people who have explained are people who agree with what I did. Say that what I did was perfectly right and reasonable. That includes professional firearms trainers, current and former law enforcement officers, military people. They all agree with what I did, completely in line with how someone should act in that particular situation. Another interesting thing is there is no duty to retreat. You know, there were a lot of these vague references to a clear path of escape. I was going down the clear path of escape. I'm not going to turn my back to these people and try to outrun them. I'm weighed down. I've had knee trouble. I have my gear with me. I'm not going to try to outrun them. So that was actually ruled in State versus Sandoval, the state Supreme Court, just like in the Kenneth Wood case, ruled that there is no duty to retreat in order to exercise self-defense. This is further solidified by a recent case here in Multnomah County. You guys may have seen this in the news a few months ago.